One of the big questions that you'll be confronting when you work through the readings, particularly the two chapters that you've been asked to read this week, is the question of how much autonomy should artificial intelligence or the robots have in order to make decisions on our behalf. How do we ensure that they can be trusted? Does that mean that they need to be transparent, reliable? And how do we know these things generally about the people or governments that we deal with anyway? This idea of autonomy is really fundamental to answering that question. George Borges defines autonomy as follows. From a legal perspective, a characteristic feature of an autonomous system is the ability to perform actions that are not controlled or predetermined from the outside, but are controlled by the system itself, depending on the environment that it perceives. That's really interesting, isn't it, that language? The environment that it perceives. This ultimately leads to the situation, which is relevant in a number of areas of law, that the concrete behaviour of an artefact in a specific situation cannot be attributed directly to control or to programming by a human being. Now, as we move next week into this question of liability, we'll continue to explore this idea of responsibility for the output of an AI or a bot. But today, our focus is going to be more generally on the broader legal considerations that arise when humans interact with or systems interact with bots or AI that effectively make decisions about what is important or unimportant and that affect people's lives or the environment around us. Until relatively recently, technologies have often been deployed more like tools. So a pen or a paintbrush moving through to a word processor or an Excel spreadsheet. But autonomy and self-learning mean that robots, intelligent AI systems, are less and less machine-like, less and less tool-like. AI will ultimately equip machines, robots, and other systems with the ability to learn using machine learning algorithms, something we spent a bit of time talking about last week. They will have the ability to interact with and work alongside us or to augment the work that we do. And that will increasingly result in them taking over functions and roles, and perhaps more significantly, deciding what roles and functions could be replaced and what decisions need to be made. Historically, new technologies have always affected the structure of labour markets, and changes like that lead to significant impact on employment, and often these impact lower skilled and manual jobs first. So think about ultimately what the impact of Ford rolling out a production line for Model T Fords back at the turn of the last century, what that impact would have been on cartwrights. Have you ever heard of a cartwright? They're people who make the wheels for carts. If any of you ever have the time to just wander into the Trades Hall, which is not far from campus, and have a look at some stage at the lists over the last 150 odd years in Victoria of people who were president of the equivalent of the ACTU, you will see their names, and what I find fascinating, the name of the trade or the union that they represent. And it's effectively a list of dead roles, which is a terrible thing to say. But, it lists the cartwrights and the stonemasons and hat makers, tailors. Now, many of these roles are done completely differently today from how they were done many years ago because of technology. The kinds of skills that a mechanic my age learned are completely different from what an apprentice mechanic learns today, because the nature of the insides of a motor vehicle have changed substantially. So the pace and the spread of autonomous and intelligent technologies, ultimately which outperform humans on the specialist tasks that they do, are radically challenging some of the base tenets of our labour laws. Well, according to the reading that you have anyway. And they raise a number of really interesting questions. I've got summaries of those questions from the reading listed on the slides, and effectively the reason for pointing this out is when you do the reading, I want you to be thinking about these questions and thinking about, are they new questions? Are they relevant questions? So, for example, our current labour and employment laws, so sick leave, working hours, taxation, minimum wage, overtime pay requirements, all of those kind of things, they were designed for people, not for robots. We don't know yet really what is the legal relationship that robots and human employees have with each other in the workplace. What about safety? What liabilities will apply if a robot harms a human co-worker? This is really more of a topic for next week, but still we need to understand where these issues are coming from. How would data protection and privacy regulations apply to personal information that's collected and consumed by bots, maybe never actually accessible by human people at all? Who would be responsible for cybersecurity or for criminal use of robots and AI? Also, what happens to the people whose jobs are being displaced? Are there or should there be statutory protections and job security for humans that are displaced by automation and robots? Should we be taxing the owners of robots to pay for the training or retraining of workers who might be displaced by those bots, by automation? Should there be a universal minimum basic income for people who are displaced? Germany, France both have social plans that come into effect when organisations are restructured because of automation, to ensure that employees who are disadvantaged by that are adequately dealt with. The QR code that you have on the screen will take you to some really interesting data that McKinsey have compiled, showing what kinds of jobs are being disrupted by automation and by AI, and conversely, which ones are growing. So why are we even thinking about this? Particularly some of the questions that the authors of the 2 chapters you've been asked to read raise seem to be about whether or not the AI itself should have some rights here, whether we should be legally protecting the bots. Now, this is a really interesting question. It's a little bit esoteric for sure. But when we think about the development of rights generally, it's actually not that long ago that certain types of people were not seen as being fully deserving of rights. In Australia, Aboriginal people, for example, women didn't have the full rights of legal personality until relatively recent in most Western cultures. We think about animal rights. These are something less than human rights, but we still believe, most people would agree, that animals have a right to be treated humanely. So as we're seeing intelligent activity, whatever that intelligence means, particularly from a general AI, can and should we be thinking about what rights that technology should have? A case study that comes up in the Wong reading from memory, I don't think it was George Burgess, no, I think it's Anthony Wong's reading, is a case study that looks at financial services technology, fintech. So more and more fintech companies are emerging to challenge the roles of banks and traditional financial institutions. And many of those are effectively working through both a set of financial information, so data, information about investment products that are available, and then the needs and requirements of the banking customer. Um, Basically, these machines or these robo advisors have been designed and modeled and programmed by humans to operate behind the scenes to assist people who interact with the consumers. But we don't think it's going to be very far, just looking at what's happening with ChatGTP, before humans will be interacting directly, or investors will be interacting directly with these machines. Um, some of you might be aware that over the last few years, there was a Financial Services Royal Commission, which was really looking at the kind of behaviours and issues that arose with human advisors acting in their own interests effectively rather than giving investors the best kind of advice. So back in 2017, following a number of these scandals, a range of professional standards legislation was developed for human financial advisors. This basically came out under the Corporations Amendment Professional Standards of Financial Advisors legislation. So that's Commonwealth Act. The regulations set a higher competence and ethical standards than what had been there previously for advisors. They included requirements for first or higher degrees, so competence, so some sort of academic training, continuing professional development requirements, and compliance with a code of ethics. The initiatives were introduced into a profession that was already under pressure from the robo environment. And because robo advice is designed, modeled, and programmed by people, the question has arisen whether or not the people who do that programming should also be required to have the same standards of education and ethics as human advisors who interact with human investors. Depending on the size and the governance framework of an organisation, a range of different players are involved in the development of what ultimately comes out as robo-advice. These include the developers themselves, but product managers, senior management, service providers, distributors of the financial product, a range of different humans. And it's very hard in that situation to point to one person who is or should be responsible for the whole thing. In 2016, actually before this the professional standards legislation came out, ASIC, so the Australian Securities and Investment Commission, put together some guidelines for monitoring and testing algorithms that are deployed in robo-advice situations. This regulatory guide, 255 from memory, the regulatory guide requires businesses that are offering robo-advice to have people who are in the business who understand the rationale, risk, and rules that are used by the algorithms and have the skills to review the resulting robo-advice. So we need to think then too about the competencies and skills of the people who undertake that role. In Europe, the EU data GDPR, the data protection regulations, have gone even further. They place explicit onus on the algorithmic provider to provide meaningful information about the logic involved. In addition, the GDPR provides individuals with explicit rights, including the rights to obtain human intervention, to express their point of view, and to contest the decisions that have been made solely by a robot. In Australia, at this stage, there is no explicit law that actually requires, in a robo advice scenario, for a investor to be even notified that they are dealing with a robo advisor. Although interestingly enough, they probably are aware when it is happening, because those who are developing robo advice are so proud of it that they're telling people when they do it. In fact, sometimes they're overinflating it, and even when there are human beings sort of under the carpet in a kind of magical Wizard of Oz scenario actually doing the work, sometimes they're pretending it's automated even when it isn't. The QR code on this slide basically says, the QR code on this slide will take you to RG255, which is the regulatory guidance for providing product advice to retail clients. Okay, that's the first of this series about the impact of autonomy. In the next one, I'm going to be talking a little bit more about intellectual property rights and what happens when robots create things or invent things. Questions, concerns, frustrations, compliments? You know where to find me.